So, Kyle, we don't think that it can be completed, your case.
I think so.
1 o'clock, we have to rise. Tomorrow, again, same thing. Monday will be same thing.
Yes, Chief will. Hostel.
Thursday, we have fixed some matters already.
Can it be on Tuesday?
We'll find out whether this bench will continue or not next week.
67.
Huh?
67.
We'll find out whether this bench can continue or not. If it continues regularly, we'll fix a date. Or otherwise, we'll fix another date. Okay, we'll pass the order we'll after inquiring with the registry. This 1 to 3. Your cases. We don't think it is possible. We'll complete another issue. Postmortem, Dr. William Mr. 17. PW 7. Perform the postmortem examination on the dead body of the deceased, Libison, Terang, on 2012-2002. In reference to Pokajan Police Station case number 164/2002. Postal. On examination, he found bleeding present in the wounds. Page 17, outside. In a wound of the scalp of occipital bone and frontal bone of the deceased. Postal. There was a sharp cut on the scalp extending from mid of occipital scalp to the right side of the occipital scalp, just above right cervical vertebra. There was a sharp cut of the scalp extending from mid of occipital scalp to the frontal bone scalp, and the membrane were found ruptured. The brain matter and blood vessels of occipital and frontal region were found ruptured. PW7 described the injuries in the following manner. Here, page 17, A2, A. PW7 opined that the injuries were antemortem in nature and were caused by sharp weapon. He further opined that the death was due to shock and hemorrhage. Video 7 exhibited the postmortem examination report as Exhibit 5 and his signature therein as Exhibit 5-1. Full stop. Video 7 also identified the signature of the Joint Director of Health Services Karbi Anglong Gifu in EXT5 as EXT52. Full stop. When cross-examined, he stated that he found presence of rigor mortis on the body and observed that normally, rigor mortis remain present after occurrence of 40 plus 60 hours. First of all. Para. PW9, as stated above, was the initial or was the investigating officer who had completed substantial part of the investigation initially after being entrusted with the investigation on lodgement of the FIR. Full stop. PW9 stated that when he was posted as an assistant sub-inspector at Bokajan Police Station on 19/12/2002, the informant, PW1 lodged the FIR and the same was registered by the officer in charge, Bokajan Police Station, Mohammed Sofiullah, within bracket PW8. And entrusted the investigation to him. PW9 exhibited the FIR as EXT1. Post of PW9 further stated that the informant, Lokeswar on PW1 within bracket and other four and four other witnesses, namely, Sondro Terang within bracket PW3, Lunse Killing, PW2, Jacob Orang and Beni Terang brought the dead body to the police station. Post of he examined the informant and the other four witnesses at the police station and recorded their statements. Post of. At that time, the appellant surrendered himself at the police station with a naga dao in his hands and confessed that he assaulted his wife Mala NTP, PW4, Kamini Hansepi, PW5, and Kamini Hansepi's son, Libishan Terang, within the deceased, with that dao. Postal. PW9 then took the dao from the hands of the appellant and arrested him. Postal. The appellant was thereafter kept in the lockup. Postal. The seizure of the dao was made in presence of the witnesses, Sondro Terang, PW3, Lunse Killing, PW2, Jacob Orang, Beni Terang, and Lokeswar Teron, PW1, as informed. As he learned that two injured ladies, Kamini Hansepi, PW5, and Mala NTP, there were two injured ladies. Mala NTP, PW4, he sent a requisition to the medical and health officer Bokajan Civil Hospital, which Constable Ram Singh Pro for their medical treatment. दोस्तों, thereafter, PW made inquest, conducted inquest proceeding on the dead body of the deceased, which was brought by the informant and the other four witnesses. Also, he exhibited the inquest report as EXT. William Henry. 7, along with his signature diary. Also, it was on 2012-2002, the dead body of Libishan Tarong was sent to Diku Civil Hospital for postmortem examination. And appellant was forwarded for production before the jurisdictional court with a further prayer, to record his confessional statement. So, PW9 stated that the confessional statement of the appellant was recorded accordingly, and thereafter, the appellant was remanded to jail custody. So, thereafter, the PW9 stated to have visited the place of occurrence at Hanse Gaon along with his staff and examined the house of the appellant, that is the place of occurrence. So he did not find anything to seize. So he had, however, noticed some dried blood stains on the yard of the house, courtyard of the house. So he further stated that at the time of his visit, the witnesses, Sondo Terang PW3, Lunse Killing PW2, Jacob Terang, and Benny Terang were with him. When he made inquiry about the condition of the two injured persons, Kamini and Sipi PW5 and Mala Ingtipi PW4, he came to know that they had recovered to an extent. Custom. The statements of the two injured persons were recorded by him on 23/12/2002 at Bokajan PHC. Custom. He also collected the postmortem examination report of the deceased, Libishan Teran, and the confession statement of the appellant, and the injury reports of the two injured persons. After completing the investigation, he stated to have handed over the case diary to the officer in charge of Bokajan Police Station on 28/12/2002. In cross-examination, PW9 stated that he did not notice the seized of in the court. Para. The officer in charge, Bokajan Police Station, Mohammed Sofiullah, PW9, deposed as regards the subsequent part of the investigation. PW8 stated that on 28/12/2022, the investigating officer, PW9, handed over the case diary of Bokajan Police Station, case number 164/2002 to him. Post of as he found that the investigation was complete, he submitted the charge sheet against the appellant on 31/12/2002, finding sufficient evidence against the appellant for committing the offences under Section 326 IPC and Section 302 IPC. Post of PW8 exhibited the charge sheet as EXT6 and his signature therein as EXT61. Post of in cross-examination, PW8 stated that he did not carry out the preliminary investigation of the case. Post of para PW10 was the magistrate, first class, O/O, the Deputy Commissioner Cardinal Dipu, who recorded the confessional statement of the appellant on 20/12/2002. Post of PW10 exhibited the statement of the appellant recorded under Section 164 CRPC as EXT 8 and his signatures therein, and his signatures and the signatures of the appellants therein. Pusto. He also exhibited an order dated EXT 19. An order dated 20/12/2002. We invite the EXT9, whereby the case records along with the statement of the appellant under Section 164 was returned back to the jurisdiction, to the trial court, to the court of subdivisional magistrate. Close to para. At this juncture, it is pertinent to mention that the trial court examined mentioned that the appellant had assailed the validity and sanctity of the alleged confessional statement of the appellant within bracket EXT 8 during the trial, and the trial court had tested the validity and sanctity of the said confessional statement. What are procedural safeguards required? Safeguards and the legal formalities required to be followed as per the provisions of Section 164 CRPC. it has emerged from the evidence. It emerged from the evidence of PW 10 itself that testimonial, testimonial PW 10 itself that there were during the time of during the uh, 3 hours time given to the appellant for reflection, there were police personnel from PI court outside the room where the appellant was kept for reflection. Postmortem. It further emerged that the appellant uh, told him that he would like to depose in Assamese language. But PW 10 recorded the statement of the appellant in English language. Full stop. Having regard to the proposition laid down in Sarwan Singh Rotan Singh versus State of Punjab, AIR 1957, SC 637, the trial court had found that minimum 24 hours time was not offered to the appellant for reflection before recording his statement under Section 164 CRPC. The trial court reached a finding that PW 10 did not deal with the statutory provisions of Section 164 CRPC as per law while recording the confessional statement of the appellant. And therefore, it cannot be said that the statement made by the appellant was voluntary and completely free from any possible fear and influence of the police. First of, the trial court proceeded to observe that the confessional statement of the appellant cannot be taken into an account and relied upon. In support of the prosecution case. First of, in view of the finding reached by in view of the finding reached by the trial court, insofar as the confessional statement EXT 8 of the appellant, it is to be looked whether, notwithstanding the said confessional statement, the prosecution has been able to bring home the charge against the appellant beyond all reasonable doubt. First of all, right now. The foremost issue, the first issue which is to be dealt with is whether the death of the deceased, Libishan Terran, a boy of about 3 years of age, was due to an act of murder. First of all, in the scheme of the Indian Penal Code, culpable homicide is the genus and murder its species. First of all, murder is culpable homicide, but all culpable homicide are not murders. First of all, culpable homicide sense SNS. Special characteristics of murder is culpable homicide not amounting to murder. Full stop. It can be said that the Indian Penal Code recognizes 3 degrees of culpable homicide. Full stop. The first is, what can be called, culpable homicide of the first degree. And it is the gravest form of culpable homicide, which is defined in section 300 as murder. First of. The second form can be termed as culpable homicide of the second degree. First of. This is punishable under the first part of section 304 IPC. First of. Thirdly, there is culpable homicide of the third degree, and it is the lowest form of culpable homicide. And the punishment provided for it is also the lowest. And punishment is provided under the second part of section 304 IPC. First of. The after discussing uh, considering after making a detailed survey of a number of precedents, including Bhirsa Singh versus State of Punjab, AIR 1958 SC 465, and State of AP versus Raya Harapu Punaya, 1976 4 SSC 34, the Honorable Supreme Court in Hungary versus State of TN, 2005 9 SSC 650, has elucidated, has brought out the distinction between culpable homicide amounting to murder and culpable homicide not amounting to murder in the following way. You're wrong, mother. I know. Where are I? 22. 22. It is also settled that the intention to cause death can be gathered from a combination of a number of circumstances. Within bracket 1, the nature of the weapon used. 2, whether the blow is aimed at a vital part of the body. 2, 3, the amount of force employed in causing the injury, stroke injuries. 4, whether the weapon was carried by the accused. 5, whether the accused dealt a single blow or several blows, etc. The circumstances above are obviously not exhaustive. There may be several other circumstances with reference to individual cases. Post stop. In the case in hand, the disease who was a child of only 3 years of age, was dealt 2 blows. And been postmortem examination too. 10, as emerged from the testimony of the autopsy doctor, PW 7, and the PME report in bracket EXT 5, comma, full line 2. Down. Was built. Comma, at a vital part of the body, and as a result of the blows, comma, brain matters and blood vessels of occipital region and frontal region were ruptured. Full stop. The assault made was fatal, comma, as full stop. The said injuries sustained by the disease were antemortem in nature. So the autopsy Dr. PW 7 had opined that the injuries caused, the assault made on the disease was, the death of the disease was homicidal in nature. Post op. The defense had not post op, having regard to the nature of injuries caused on the disease and the circumstances. We are of the clear view that the date of the disease was clearly was homicidal in nature. Full stop. The injuries sustained by the injured witness, comma, Kamini Hansepi, was found to be grievous. Full stop. The treating doctor, comma, PW 6, in his testimony stated that the deep cut injury sustained by PW5 on the right side of her neck was by a sharp cutting object, and the nature of injury was grievous. Full stop. EXT 4.7. The injured, Kamini Hansepi was examined by PW 6 on 19/12/2002, and the said fact is recorded in the injury report, EXT 4. Also, from the above discussion, it has clearly emerged that the Kamini Hansepi, PW5, sustained a grievous injury on 19/12/2002. Also, para. It is the learned amicus curiae has rightly, no, not, is found correct in his submission that PW5, Kamini Hansepi did not testify specifically as regards the assault made on her deceased son. Leaving aside that aspect, when we examine her testimony, it is evidently clear that we find that PW5 testified to the effect that on the date of the incident, 19/12/2002, she along with her child, went to the house of the appellant to inquire about the health of the appellant after learning that the appellant was suffering from some illness. PW5 had clearly testified that the appellant had made cut injuries on her on various parts of her person, and as a result of being hacked, she fell unconscious at the place of attack itself. Also, the defense did not question PW5, they did not question anything, did not put any question to PW5 as regards such assault made by the appellant on her. Stop. The line in which the defense had questioned PW5 would be adverted to in a later part of the poster. But it is the it was PW3 Sondro Terang who had testified about the assault made on the deceased had testified about witnessing the assault made on the deceased by the appellant. Poster. PW3 had categorically testified that he saw the appellant hacking the injured Kamini Hansepi's son with a dove in the courtyard of the appellant. PW3 further also testified that as a result of the hacking by the appellant, the child died in the courtyard of the appellant itself. Poster. PW3 also corroborated a version of PW5 Kamini, NCP, that the appellant hacked her too. And as a result of such hacking, Kamini and Hansepi fell on the ground, losing her consciousness. Pusto. The testimony of PW3 on the said two vital aspects could not be demolished by their defense in any manner whatsoever during his cross-examination. Rather, it was elicited from PW3 that when the appellant had the disease and Kamini NCP, the father-in-law of Kamini NCP, Pota Orang, was in his house consuming liquor. From the manner of such cross-examination, it has been implicitly admitted that by the defense that it was the appellant who had the disease as well as Kamini Hansepi. Para the testimony given by PW3 was has been assailed on the ground that PW3 appears to be a chance witness. Before that. Separated from the separated from the hearing development. Moral development. Each. Sanskrit is a disil now. Sanskrit means about Sanskrit. Your needs to should later. Sorry. Two sons. Sons. I'll say sons. injurial ago. A such witness is the one who happens to be at the place of occurrence of an offense by chance, comma, and therefore, comma, not as a matter of course, full stop. In other words, comma, he is not expected to be in the said place. Full stop. It is explained, it is elucidated in Rajesh Jadhav and another versus State of Uttar Pradesh, 2022, 12 verses 200. To the effect that a person walking on a street witnessing the commission of an offense can be a chance witness, first off, merely because a witness happens to see an occurrence by chance, comma, his testimony cannot be skewed, though a little more scrutiny may be required at times. And this is an aspect which is to be looked into in a given case by the court. Full stop. It is well settled that well settled. It is a well settled legal principle that the evidence of a chance witness cannot be brushed aside simply because he is a such witness, but his presence at the place of occurrence must be satisfactorily explained by the prosecution so as to make his testimony free from doubt and thus reliable. First of para. In State of UP versus K. Srinivasalu Reddy, 2003, 12 SCC 616. Commander Honorable Supreme Court has observed as T to D, or in Zarnil Singh versus State of Punjab, 2009, 9 SSC 719. The Supreme Court as regards such witness has observed as well. There have been lot of issues. Coming back or reverting back to the testimony of PW3, it is found that PW3 is a brother in relation of the husband of the injured witness Mala Kamini Ansepi, that is, Sarsing Terong, DW1. First of it has been elicited from PW3 by the defense that on the date of the incident, PW3 had gone to the village of the appellant, PW4, PW5, and DW1. To the village to visit the house of DW1 and PW5. Question. When it was in the course of such visit when PW5 was in front of the house of the appellant, comma, a house adjacent to the house of PW5 and DW1, comma, PW3 testified to have witnessed the incident of assault on PW5 and the deceased in the courtyard of the appellant by the appellant with down. Post of PW3 testified further to the fact that after committing the assault, the appellant had proceeded towards the police station with a dove in his hands, which is a circumstance to be considered under Section 8 of the evidence. The fact of appearance of the appellant at the police station sometime after the incident, which occurred in between in and around 10 in on 19/12/2002, has been corroborated by the informant SPW1 and the IO, PW 8999. Full stop. Para. Mayor. Non-mentioning of the in view of such categorical emphatic testimony of PW3 regarding the assault made on the minor child of the injured witness, PW5, non-mentioning of the alleged failure to mention alleged failure on the part of the injured person, PW5, about the assault made on her minor child would pale into insignificance. First of all, it is relevant to mention that from the testimony of PW3 and PW5, 5, it had emerged that as soon as assaults were made by the appellant on PW5, she lost her consciousness immediately. So, therefore, it is quite possible for PW5 to have lost consciousness prior to the hacking of the minor child by the appellant. In any matter of the view, the defense has not been able to disturb the categorical testimony of PW3 in any manner whatsoever. The PW3 there is no evidence on record to suggest that PW3 had any kind of animosity either with the appellant or any member of his family, including PW4. Postmortem. It is sorry, so occasional visits to near relations is prevalent in rural areas and among the village folk. So does, the presence of PW3 at the place of occurrence at the time and date of the incident cannot be viewed with any suspicion. When he was not a stranger having emerged suddenly out of nowhere in the scene. Full stop. Para. It has further emerged. It has further emerged from the testimony of DW1 that it has further emerged from the testimony evidence on record that PW3 After the incident of assault, PW3 took the injured Kamini Hansepi to the hospital. Prior to that, from the testimony of DW1, it has emerged that prior to taking the injured person to hospital, PW3 went to the school of DW1 to inform him about the incident. Postdoc. PW3 was found to have taken initiatives to take the dead body of the deceased to the police station, as testified by the IOPW9. Postdoc. PW3 was a witness to the inquest. Page 96. Proceeding, as well as a signatory to the inquest report, EXC2. Postdoc. The PW3 was also a signatory to the seizure list EXC3, whereby the IO PW9 seized a Naga dao fitted with a bamboo handle, having its sharp end about 8 inches long. Postdoc. The PW3, along with the informant PW1, also was also instrumental in taking the dead body of the deceased to Diffuse Civil Hospital. And the autopsy doctor PW9 testified to the fact that a disease was brought by PW3, PW1, that's informant, and a constable. Oslo. Thus, we find that the assay made regarding the assay made that the assay made to disregard the testimony of PW3 has no basis at all. Postal. After, after stating that he would adduce evidence in his support, comma, the appellant examined, searching, page 28. Terang as DW1, Pusto. DW1 Sarsing Terang was the father of the deceased child and the husband, and is the husband of injured Kamini Hansepi. Pusto. In his evidence in chief, DW1 deposed that the appellant is his brother-in-law, the disease, Libishan Terang was his son, and the injured, Kamini Hansepi is his wife. He says, she's my sister, Allah. Postal. He further testified that the occurrence took place on 19/12/2002, and on that day, he who, a lower primary school teacher, went to the school for duty at around 8:30 a.m. Postal. DW1 stated that 2/3 days prior to the occurrence, appellant was suffering from illness. Postal. When he was at the school, PW3 and another person from the village came to his school to inform him about the incident. So then, DW, then he came to his house and found that his son and his wife were on the bed inside the house. Pusto. DW once stated that his son, Libisham Tenang, had already expired, and his wife, was struggling for her life. Then, he took his wife, Kamini and Sepi, to Bokajan Hospital at first. And from Bokajan Hospital, his wife was taken. He took his wife to Nimapur Civil Hospital as per the advice of the doctors at Bokajan Hospital, who provided the initial treatment there. DW1 further stated that when he arrived at his house, not it is his house. Where during cross-examination, DW1 stated that the incident took place in the house of the appellant. Full stop. It was after an hour from the incident, he came to the place of occurrence. DW1 reiterated that it was PW3 and another person from the place, who informed him that the appellant had cut his son and his wife. After the incident, the villagers took his son and wife to his house, and he saw cut marks on the head of his son, Division Terang. DW1 further stated that when he arrived at his house, he found his son already dead with many cut injuries and noticed many cut injuries on the person of his wife. Full stop. Para. When we examine the testimony of DW1, we have not been able to find anything in the testimony of DW1 which supports the case of the appellant. Full stop. On query, the learned amicus curiae has submitted that the fact deposed by DW1 to the effect that 2/3 days prior to the occurrence, the appellant was suffering from illness is relevant. Full stop. The learned amicus curiae has further submitted that it is the testimony of PW4 coupled with the testimony of DW1 which would go to indicate about the factum of unsoundness of mind, factum of mental incapacity of the appellant at the time of the incident. Para. Corporation, no? Corporation. kind of witness. Kind of witness. The witness. Only category partly reliable, partly unreliable. Options like only unreliable. Value give an idea about answer. Value give an answer. No. In value, Honorable Supreme Court has observed that having regard to the nature of testimony, uh, witnesses can be categorized in three categories. Small Roman one, wholly reliable. Small Roman two, wholly unreliable. And three, there's.
It's fully reliable, fully unreliable, and partly reliable.
Hardly. They got to value indicators.
Fully reliable, fully unreliable, and partly reliable.
When we closely examine the testimony of PW 4, Malah ing TP. We find the witness to be of the third category. Goes down. PW 4 the PW 4 is found to have corroborated found to have supported is found to be supporting the case of the prosecution as regards the time, date, and place of the incident. And the fact of the diseased minor child lying dead in the courtyard of her house. Full stop. PW5 is also found to be supporting the case of the prosecution about sustaining injuries by Kamini and Hansepi, PW5. Full stop. At that time, in and around the time of the incident, the PW4 was found to be in her house. Was found to be in her house. Full stop. PW4 is found to have taken a vacillating stand as regards her presence by deposing that at the time when the incident of assault, or at the time when the incident of assault took place, as told to her by other persons in the village, she had gone out to fetch water. Full stop. As the PW4 further stated to have fled from her house to return only on the next day. Full stop. The reason why we find this witness as partly reliable, partly unreliable case is that from the testimony of neither wholly reliable nor wholly unreliable. That is the word. That is why I did not subscribe to your submission that partly reliable. Neither wholly reliable nor wholly unreliable. Right? For the reason that it has clearly emerged from the testimony of medical officer, PW, PW6, the medical officer who treated and the injury report, EXT, wherefrom it has clearly emerged that PW4 was given treated, was provided medical treatment at Bokajan PHC at around 1 p.m. on 19/12/2002. Full stop. PW4 was found to have sustained a deep cut injury of her frontal scalp involving muscle and blood vessels by a sharp cutting object, and the nature of injuries PW4 had sustained was simple in nature. Full stop. Will come out. Last line diesel. One cannot be oblivious of the fact that PW4 so and so, is the wife of the appellant who was facing charges of committing murder of one and causing grievous hurt to another. Full stop. Faced with such situation of her husband, of visiting, of being visited with severe punishment, the possibility of describing the incident, or describing the manner in which the incident took place, possibility of describing the incident in a different manner by PW4 Possibility of describing the incident in different manner with PW4. Possibility of describing the manner in which the incident took place. By PW4. Take by now. To extricate her husband cannot be ruled out. Also, being the wife of the appellant, a person like, no, it is plausible. It is plausible that a person like PW4 a person as situated like PW has the tendency to extricate an accused husband from the clasp of a charge like murder in fill up করি। Custom. Para. From the upon analysis and appreciation of the evidence on record in its entirety, comma, we find ourselves in agreement with the trial court that the date of the deceased, comma, Libishan Terang, the child of 3 years, was a homicidal death. Post op. The deceased had suffered fatal injuries of the nature described above on the vital part of the body. Post op. From the testimonies of the witnesses, comma, more particularly, comma, PW3, it is evidently clear that it was the appellant who had inflicted the fatal blows on the deceased, which was sufficient in the ordinary course of nature to cause death. and the offense is clearly under clause thirdly of section 300 IPC, meaning thereby, comma, it was a case of murder. Full stop. এটা পৰা থাকিব injured witness, huh? এটা পৰা. From the testimony of PW, from the it has also been fully established that upon analysis and appreciation of the evidence on record in its entirety, comma, it has been fully established that it was the appellant who had caused grievous hurt to the injured so-and-so PW5. Full stop. Therefore, we are of the unhesitant view that the findings reached by the trial court as regards guilt or the appellant for the offense says under section 300 and section 326. And therefore, we have found, no, full stop. Para. Do the it is there can be some variations in the statements of witnesses with respect to a particular incident. Full stop. Every variation or immaterial contradictions does not provide advantage to the accused. Full stop. The variations or contradictions, sought to be highlighted on behalf of the appellant in the case in hand, are found to be immaterial. First of it is subtle principle of law that while appreciating the evidence, the court has to examine the evidence in its entirety upon reading the statements of the witnesses as a whole. And if the court finds the statements of the witnesses, more particularly the material witnesses, to be truthful and worthy of credence, then any variation or discrepancy of minor nature, minor and immaterial or of minor nature, which do not affect the root of the case of the consequence would be of no consequence. Full stop. In the case in hand, comma, the incident that had occurred on 19/12/2002 and except PW1 who was examined in September 2009, comma, all other witnesses were examined only in July 2018 and thereafter. Full stop. Some lapses in memory would definitely happen if a witness is examined after such long lapse. Full stop. But having examined and appreciated, having examined and analyzed the evidence on record in its entirety, comma, the minor variations have not affected, minor variation occurred, have not affected the core case of the prosecution. First, insanity issue, insanity issue. এটা কি কাম? আগতে আগতে হেৰি কৰা ৰ'ব থৈ দিয়ক লিখিছে IPC. Chapter Roman 4 of the Indian Penal Code has dealt with general exceptions. दोस्तों Section 84 of the IPC, with a nominal heading, quote unquote, act of a person of unsound mind, comma, has provided that nothing is an offense which is done by a person who, comma, at the time of doing it, comma, by reason of unsoundness of mind, comma, is incapable of knowing the nature of the act, comma, or that he is doing what is either wrong or contrary to law. Full stop. When a plea of insanity is raised on behalf of an accused, comma, the court has to consider whether at the time of commission of the offense, the accused by reason of unsoundness of mind, comma, was incapable of knowing the nature of the act, or that he that he was doing what was either wrong or contrary to law. Full stop. The crucial point of time for ascertaining the state of mind of the accused is the time when the offense was committed. Full stop. Whether the accused was in such a state of mind as to be entitled to the benefit of Section 84 of the Penal Code can only be established from the circumstances which preceded, comma, attended, and followed the crime. Full stop. For consideration of a plea of insanity, no, Section 101 of the Evidence Act places the burden on the prosecution to bring home the charge framed against an accused. So once the prosecution has been able to bring up home the charge against the accused by way of cogent, comma, credible and reliable evidence, comma, it is thereafter the court has to examine whether the case of the appellant falls within one of the general exceptions, like Section 84 of the Penal Code. And for examining such an issue, comma, the principle of the rules of evidence embedded in Section 105 of the Evidence Act is to be 105 springs into action. Also evidence. As per section 105 of the Evidence Act, comma, as speaks of the burden of proving that case of the accused would come within exceptions. Question. As per section 105 Evidence Act, when a person is accused of an offense, comma, the burden of proving the existence of circumstance bringing the case within any of the general exceptions in the Indian Penal Code, comma, or within inter equity. When a person, yes, or within any special exception or proviso contained in any other part of the penal code or in any law defining the offense, comma, is upon him, and the court shall presume the absence of such circumstances. Full stop. In the present case, comma, there is no evidence. No, no evidence. There is no evidence has been brought on record to the effect that the appellant was at any time, comma, prior to the incident, comma, had been treated medically for mental insanity. So, in other words, comma, no previous history of the appellant's insanity has been revealed from the evidence on record. Full stop. Only the only material, sorry, the materials available are, sorry, not like material. The only materials which have been referred to on behalf of the appellant are from the testimony of PW4, comma, PW5 and EW1. Full stop. PW3 4 stated that the appellant was ill from 3 days prior to the incident, and he showed a restlessness with a tendency not to stay in the house, and showed scariness. In presence of a third person. The testimony of PW5 as regards illness of the appellant, comma, as evident from above, comma, is neither here nor there. Full stop. Though DW1, no, though DW1 was purportedly brought in by the appellant to testify about the mental incapacity of the appellant, comma, DW1 only testified to the fact that 2-3 days prior to the incident, comma, the appellant was suffering from illness. Full stop. One. These are all. Down. And the testimony of PW so sorry. The fact regarding his illness, comma, as deposed to by PW4, comma, was brought to the notice of the appellant during his examination under section 313. Post of, but the appellant negated it by saying that the same was not true. Post of. Similarly, when the victim of illness as stated by PW5 during her testimony, was brought to the notice of the appellant during the stage of his examination under section 313 CRPC. The appellant also negated the same by categorically stating that the same was not true. Full stop. এটা প্যারা লিখি, এটা প্যারা when the appellant was asked whether he had anything further to state other than clearing, other than making it a the appellant did not speak anything about his mental capacity or mental incapacity. But in the from the facts and circumstances of the case, and upon examination of the records of the trial court, we are unable to find anything on record for which the benefit of section 84 IPC can be extended to the appellant. Full stop. Para. In view of the discussion made above and for the regions recorded above, comma, we find ourselves in agreement with the conviction the judgment and order of conviction and sentence rendered by the trial court. Full stop. Therefore, comma, the conviction and sentence passed against the appellant for the charge under section 302 IPC and section 326 IPC are affirmed. Full stop. The trial court have ordered the sentences to run concurrently, and we do not find any reason to disturb the sentences. Resultingly, comma, the criminal appeal fails. Full stop. Para. B. Prasad. Makes return of the trial court for compensation. Compensation part. What's an order? Compensation, 57, 16 compensation. Does make sense? Ase. We reiterate. It is reiterated that we reiterate the direction made by the trial court in paragraph 61 of the judgment and order dated so and so as regards payment of compensation, and it is ordered that if the compensation has not yet been disbursed, comma, the same should be disbursed with utmost expedition.
The series better my government.
Serious matter.
That series better my you was already 1 to 3 my government.
Huh. No, we are trying because I have already said
Yes, madam, that's
let me find out from the registry whether this bench will be formed next week or specially this is to be formed. There are many things changing, right? So if this bench is special today,
special, but not normal.
not normal. So whether this is to be specially formed or it would be a regular bench in the next week, right?
Regular, no problem.
If regular, no problem. If special, then we have to see the business of the court. That is why I have said that we'll fix on a date, but let me inquire also.
Yes. Why only paper? 10
Because
years
things
old?
are changing,
Yes, yes. Very well. Only because I was 10 years already gone now.
right? We are concerned, that is why we have kept it part, right?
Okay.
The other bench will not sit.
Tomorrow same thing will happen.